Welcome back to Law Wire. Today, we're dealing with an important concept of the Indian legal system, plea bargaining. Origin of plea bargaining in India. Pursuant to the Malimath Committee report, the central government introduced the Criminal Law Amendment Act 2005. Plea bargaining, or mutually satisfactory disposition, was introduced then by means of Act No. 2 of 2006 within the Cr.P.C. What is the rationale behind plea bargaining? The Indian legal system faces a backlog of cases, and plea bargaining is intended to help expedite the process, save resources, and promote efficient justice delivery. Limitations of plea bargaining. It may be entered only in such offences which are punishable up to 7 years of imprisonment, but excludes the offences affecting socio-economic condition of the country or offences against a woman or a child below 14 years of age. This is recorded in Section 265-A of the Cr.P.C. What are the various types of plea bargaining? First, charge bargaining. This is the most common type of plea bargaining. It involves instances wherein the accused agrees to plead guilty to a less serious charge than the original one in exchange for a reduced sentence or other concessions. Second, sentence bargaining. Herein, the accused pleads guilty to the original charge but negotiates for a lighter sentence. This might involve the prosecution agreeing to recommend a shorter prison term or alternative sentencing options like probation or community service. Third, fact bargaining. In this type of plea bargaining, the defendant agrees admitting certain facts in the case. These facts can impact the charges or potential penalties. Pros and cons of plea bargaining. Let's now examine the pros and cons of plea bargaining. Pros: expeditious case disposal. By avoiding the trial process, the backlog of cases can be addressed with. Second, record. This may help in one not having serious offences on one's personal records. Third, escaping jail. In cases wherein an accused is arrested and is unable to get bail, he may plea bargain and get out of jail. Fourth, resource saving. Since this avoids the trial process, thus it saves litigation cost and time. Fifth, privacy. An individual may choose to avoid the hassles and publicity of a trial, thereby plea bargaining and avoiding the news of a trial getting public. Cons. First, misuse of trial. Prior to the enactment of this law, the Indian courts have time and again held that any mechanism that avoids trial is unconstitutional. Second, practicality. This process is not practical as it is highly unlikely that the interested parties come to a mutual consensus. Lack of cases in this regard is proof enough of this fact. If you found this video informative, don't forget to like, share and subscribe to Law Wire.